Hello everyone, my name is Brock Hammond, and the case that I will be discussing is the American Legion versus the American Humanist Association. This was a case consolidated with another case called the Maryland National Capital Park and Planning Commission versus the American Humanist Association. The three justices that I have been assigned for this project consist of one conservative justice, Clarence Thomas, and two liberal justices, both appointed by the same president, Barack Obama, Sonia Sotomayor, and one of my personal favorites, Elena Kagan. In order to understand my predictions for each justice, I will give you an overview of the case at hand. This case involves the 40-foot Bladensburg Cross, which is found in an intersection in Bladensburg, Maryland. This cross was dedicated in 1925 as a monument in honor of Christian soldiers who died in World War I. The Maryland National Capital Park and Planning Commission currently owns and maintains the cross. One point of contention is who owned the cross to begin with. The American Legion argues that the cross was constructed and designed by private parties, while the American Humanist Association points out that the town had to approve the building of this cross and that the town owned the property on which the cross was built to begin with. As of 1935, as we learn in the brief submitted by the American Humanist Association, we learn that the state of Maryland did claim ownership of the Bladensburg Cross. And a 1956 circuit court ruled in their favor and said that, yes, this was in fact property of the state of Maryland. However, in 1960, the Maryland National Capital Park and Planning Commission took ownership of the cross for, as the American Humanist Association brief reads, quote, "the future repair and maintenance of the monument," end quote. Ultimately, the Supreme Court must rule whether or not the ownership and maintenance of this cross by the government of Maryland violates the First Amendment Establishment Clause. Now that you know more about the case at hand, I'd like to share with you my theory of judicial decision-making. In my paper, I discuss the role of law, how law is interpreted, and the influences of both policy preferences and ideology. I would also like to add to that the role of the Solicitor General and the influence of amicus curiae briefs. As for the role of law in judicial decision-making, Professor Lawrence Baum writes in the textbook that while the law is hardly the dominant force in decision-making, it exerts a real impact on the court's decisions. In order to really evaluate the role of law, it's important to study how justices interpret that law. One of the ways in which we can predict justices will vote is to look at past precedent, something that they use in deciding how to vote in future cases, whether they will uphold precedent, uphold part of precedent, or overrule it altogether. Given that Justice Thomas has served on the court the longest of the three justices I'm studying, it is easy to look at his past opinions and predict how he will rule in this matter. In Elk Grove Unified School District versus Newdow, the court had to answer whether or not a school policy which required all classroom teachers to lead the Pledge of Allegiance, a pledge which identifies the USA as a nation under God, would violate the Establishment Clause. The court ruled unanimously in favor of the school district, and Justice Thomas wrote a concurring opinion in which he called into question the way we traditionally see the Establishment Clause. He argued that this clause was meant to prevent the federal government from interfering in state establishments of religion. In his opinion, he also called into question whether or not the Establishment Clause was truly incorporated under the 14th Amendment. So basically, whether or not it would apply to the states. Because as we know, the Bill of Rights in the Constitution did not initially apply to the states. And over time, the Supreme Court has gone right by right and said whether or not it applied to the state and not just the federal government. In another case, Van Orden versus Perry, he agreed with the court majority that the installation of a Ten Commandments monument on Texas Capitol grounds did not violate the Establishment Clause. In Town of Greece versus Galloway, he agreed with the court majority that prayers led at legislative sessions, in this particular case at a town board meeting, did not violate the Establishment Clause. However, by the time Town of Greece came before the court, both Justices Sotomayor and Kagan had joined the court. Each of them dissented. Justice Kagan wrote a dissenting opinion which Justice Sotomayor joined. And in that opinion, she wrote, quote, "When the citizens of this country approach their government, they do so only as Americans, not as members of one faith or another. And that means even in a partly legislative body, they should not confront government-sponsored worship that divides them among religious lines." As most of you have read the briefs in the relevant to the case that I'm studying, you know that worship and prayer services had taken place at the Bladensburg Cross throughout history. So I'm sure that Justice Kagan will be paying especially close attention to that, especially given that these worship services were exclusively Christian. We also know that policy preferences and ideology play a large role in how justices come to the decisions that they do. As we've learned in the course, we know that judges are nominated to the Supreme Court that are ideologically in line with the president that nominates them. In fact, in her confirmation hearing, Elena Kagan was asked by Republican Senator Lindsey Graham about her progressive politics, to which she explained that she had been a Democrat all of her life. He also questioned her about her work as a lawyer for the Clinton administration and certain positions she had taken then pertaining to partial birth abortion bans and so forth. And she explained that she was carrying out the policy preferences of the administration and probably her own policy preferences as well, although she did not specify that in the hearing. Republican presidents nominate conservative justices, and Democratic presidents nominate more liberal justices. In looking at precedent, liberal justices tend to be much more cautious about government and potential violations of the Establishment Clause, while conservative justices tend to side more with the government on these issues. We also know that the court looks to amicus curiae briefs filed for both petitioners and respondents in each case that comes before them. One of the briefs filed in support of the American Humanist Association was by a group of Jewish war veterans who argued that although the Bladensburg Cross was rededicated to represent all veterans, it could never possibly represent the thousands of Jewish people who gave their lives for their country because of the nature of the monument, given that it's a cross, and the cross is a symbol of Christianity. My belief is that this point of view will hit close to home for Justice Kagan, as she is a lifelong observant Jewish woman. It is also worth mentioning that both Justice Thomas and Justice Sotomayor are Roman Catholics. Justice Thomas's viewpoints have often been favorable to Roman Catholic thinking, while Justice Sotomayor, although she is also Roman Catholic, her rulings pertaining to the Establishment Clause, a woman's right to abortion, and rights for same-sex couples are often not in step with Catholic teaching. The Office of the Solicitor General frequently participates in cases as an amicus curiae, in cases that come before the court. The lawyers of this office represent the current administration and its positions. Professor Baum explains in our textbook that the court frequently invites, in reality orders, the Solicitor General to file amicus briefs at the certiorari stages in cases that do not affect the federal government directly because the justices are interested in the government's views. In this case, I would argue that the federal government does have an interest in the case, so I'm sure the justices will be especially interested to hear what the Solicitor General will have to say. It's also worth noting that Justice Kagan previously served as the Solicitor General for the Obama administration, so there's no doubt that she has the utmost respect for the office. Given what I've learned so far, I predict that Justice Thomas will vote in favor of the American Legion. And I also predict that Justices Kagan and Sotomayor will vote in favor of the American Humanist Association. So I'd like to thank you all for watching, and I look forward to hearing what feedback you may have for me. Thank you, and good night.